not telling her that, oh, this is a, adoption hearing.
Right.
So there's some issues there with, let's say, ineffective assistance of counsel.
Right. Wow, I'm shocked to hear that story. I thought I've heard everything. I've never heard a story like that one.
I want to introduce you to the law offices of Vincent W. Davis at 888-888-6582. They're advocates for the rights of parents, grandparents, and guardians in juvenile dependency courts. Losing a child to a DCFS CPS social worker based on an anonymous call, complaint, or your ex-spouse is not only horrific, but it's commonplace. Everyone will agree that there's nothing more valuable than one's child. You cannot afford to fight this alone. Call the law offices of Vincent W. Davis at 888-888-6582. Connect with an attorney today. That's 888-888-6582. Get your kids back.
All right. Good afternoon. This is Attorney Vincent Davis, and this is The Secret, How to Fight CPS and Win. Today we're going to be taking your calls, answering your questions, and listening to your stories. And I have a very special guest that's going to be joining us today. She's an attorney. She works with me. Her name is Jennifer Ani. Jennifer, are you there?
Yes. Hi. How are you this afternoon?
I'm doing fine. How are you doing?
Excellent. Thank you for asking.
Jennifer, what's been going on with your cases these days? Are you have anything interesting going on?
Oh, gosh, I sure do. I had a case last week where a mother of an infant, a newborn, had at birth suffered a stroke in the hospital. CPS was called. They assumed the stroke was brought on by drug use, and they placed the baby in foster care despite the availability of several maternal relatives who had stable homes and stable lives in the same community. The attorney, the court-appointed attorney for the mother, at the first 6-month review, of course, mom is still, she was actually in a coma for a little bit, so she's rehabilitating, speech therapy, physical therapy. At the first hearing, mom asked if she had to appear. The attorney said, no, I'll waive your appearance, and submitted on termination of reunification services, which of course starts the time for adoption to go through, 120 days. So we got the case about a month after the 6-month review, and I was just able on a JV 180 to get the 21E reset. So we're going to start back from there, and we're not going to submit on reunification services. I also obtained a hair follicle test for mom, which is negative for all substances. And we have the speech therapy and physical therapy, which was so important to the social worker during those first 6 months that mom complete to get her child back. I mean, I don't think there's any law that says you have to complete speech or physical therapy. In fact, I think we might be running afoul of the ADA here. So it's very interesting, and I'm very happy that we were able to turn that around this month.
Wow, that sounds like a great job. What happened at the jurisdictional part of this case? Was she in the hospital at that time?
Correct.
And was she?
And Juris was taken on the. There were no hospital records indicating maternal drug use. The social worker just, it was her knee-jerk reaction because the family does have a history, from 10 or 15 years ago with drug use, but there's been nothing since 10 or 15 years ago. So it was, a complete leap of faith or non-faith, as it were, by the social worker to remove from mom. A police officer even went to the home at the bequest of the father and found everything was okay, but still the social worker didn't accept that. Okay, meaning that the child would be safe in the grandparents' care.
Wow.
But placement was never done. So, yeah.
Do you think there's any possibility or likelihood of maybe even setting aside the dispositional case plan or court orders?
Well, that's we just got in the case. That is what I'm shooting for, but I'm pretty happy that I get to go back on the 2-1E. And, the attorney for the mom, of course, didn't tell the mom what was at stake at this hearing, told her, sure, don't bother coming. When mom was able to contact her after the 2-1E or the 6-month review hearing, she said, oh, well, don't worry about it. We have another hearing in a couple months. I'll let you know. Not telling her that, oh, this is a, adoption hearing.
Right.
So there's some issues there with, let's say, ineffective assistance of counsel.
Right. Wow, I'm shocked to hear that story. I thought I've heard everything. I've never heard a story like that one.
Yeah, it is. Well, and the mother still isn't able to speak well. I communicate through the maternal grandmother with the client sitting, right there. She's not able to articulate and use sounds with her voice. There's nothing at all mentally wrong with her, and so probably the social worker just decided that was too much effort for her to have to, work with the family in that way. That's what seems to have happened, and they counted the family out, but that's not the case.
Do you think it was some type of stroke, or what do you think happened?
It was definitely a stroke. In fact, she had 2, but they weren't related to. And then they tried to say that it was related to domestic violence, that she was hit in the head by the father, and that caused it. Of course, they had no substantial evidence to support that.
Right. Amazing. It was a good thing that they came to us and you were assigned to the case. Is this case in Southern California or Northern?
No, Northern.
Okay. I don't want you to name the county, but I've had some.
No, I won't. I won't.
I've had some interesting cases, from some of these Northern California counties. Art Lasalento called me this week, and he asked me a question, and it had to do with Welfare and Institutions Code 827. And,
yes.
I thought, you know what, Jennifer's an expert at that. And he and I are on a case in a Northern California county, and we made a motion to disclose reports and records in this medical-based case to our own expert, our own medical expert, a doctor, a local guy here in the Pasadena area who's one of the preeminent experts, on child abuse. And you know what the judge told us? The judge granted it, but said, you don't have to make those types of motions if you're giving it to your own expert. It wasn't like, we were trying to blast it over the news. And, Art said, well, there seems to be, every once in a while, seems to be some type of conflict, like some judges believe that you have to do that. And this judge was of the opinion that you never had to do that if it's your own expert, which is something, that I would always think, if it was our own expert, it's part of the quote unquote law office, part of the attorney.
Well, one would think that.
Right.
One would think that, but 827 by its terms allows the court to distribute social reports and other documents in the case file to certain specific parties, of which a parent's attorney's expert is not one. That's the conflict. So the law is actually in conflict, I think, because the confidentiality provisions of 827 were never intended to limit a parent's defense in that way.
Mm-hmm.
Never intended. And while I could understand if the expert were taking the documents, copying them and stapling them on telephone poles throughout town, that would be problematic. There is no other way an expert can competently do his job for a parent defense without having documents. And if the expert were to put forth an opinion based upon anything but review of the documents, the court would not consider that opinion to be relevant because it wasn't considering the facts of the case. It would be an advisory opinion at best. So I definitely think there needs to be clarification. That needs to be done by the legislature. I too, last week, asked 3 courts for, I started by saying, I understand technically I should file an 827. However, I'm wondering if I could be authorized to share the social reports with my psychiatric expert, medical expert, whatever. And of course, no problem, so I'm just getting that noted on record. And it would be time prohibitive as well. These 827 petitions don't take priority on the case. And who knows when the judge will get around to deciding them. In that Northern California case, the judge was asked at the time and granted, but it is definitely an issue that some courts take a different view on.
I once had a judicial officer question me about doing that, about giving social worker reports to a psychologist who was my expert. And initially, I think that the judge believed that I couldn't do that and, was going to maybe even have a hearing or an OSC, against me for doing that. And I, mentioned, I didn't really argue. I go, basically, are you telling me I can't give the social worker report to one of my own experts? And it kind of blew over and we never had the hearing. But I think that the judge may have thought about it, how that sounded. In other words, when it mentions attorney in the code itself, in 827 of the Welfare and Institutions Code, in other aspects of the attorney-client relation, your experts, your employees are part of that quote-unquote attorney's office. So, for example, does 827 say that my secretary can't look at the file when she's
exactly
tab and indexing it? The same thing.
Exactly.
Same thing for an expert. And the experts all understand, especially the guys and gals that do this frequently, that, all of this is confidential. They're medical doctors. It's confidential anyway. So it would be kind of redundant. But I think that in other areas of the law, your expert is part of your office. And then therefore, under CPS cases, your expert is part of your office as well.
That makes sense. I guess the sticking point is the confidentiality provisions, but it absolutely it just doesn't pass the straight face test. That because if it applied to an expert, it would apply, as you say, to office staff, to anybody, and that's just not that's not functional. So it'll be interesting to see where that goes.
I also think that it would be if cases were done pursuant to the code and there was no breaks in the case, you couldn't do an 827 and get it heard before the time of the trial. Hey, Jennifer, I would like you to hold on. We got to take our breaks here, our first break, and then we're going to come back and we're going to talk to Tashita in California. So stand by. We'll be right back after these messages.